This is Ranger Kidwell-Ross, Director of the World Sweeping Association. In our other view, you see Phil Duncan back again. Good morning, Phil.
Hey, good morning, Ranger. Good to see you.
So we're going to talk today about contract language that you are faced with, and especially from third-party vendors, and that Phil sees all the time. And we'll give you some general ideas of what to look for and what to not sign. The difficulty with signing some of these contracts is that it just really does come back to bite you. So I'm going to start off by sharing my screen, and what you're going to see is an article that is in your at worldsweepingpros.org called Third Party Liability Contract Clauses of Concern. So what we're talking about is that usually sweeping contractors, God bless you, sign the standard contracts that a third-party vendor or national service provider provides. And then only too late you find out that there are clauses that really you shouldn't have signed. Now, here's an example from U.S. Maintenance that the contractor, that's you, will defend both U.S. Maintenance and the property owner, whoever you're sweeping for, from and against all allegations, even if they may later be proven false, fraudulent, or groundless, that are asserted in any and all claims reasonably related to service you provided or failed to provide under the agreement, regardless of whether your obligations specified below ultimately apply, and regardless of whether the allegations are directed solely against one or more of the indemnified parties, in other words, them instead of you, you still have to be the first up to have your insurance be the ones to cover. And as you see the bold emphasis that I add here, for the avoidance of doubt, you are obligated to indemnify everybody else under the paragraph, even if they are negligent in causing the losses. Now, as an example I use, let's suppose you signed the agreement, swept a drugstore chain on certain but not all days through the third-party vendor with whom you signed the contract. A customer claims they fell on trash in the parking lot on a day when you were not contracted to sweep the night before. Even though the customer sues only the third-party vendor and the drugstore, the above clause would put your company on the hook ahead of all other parties, since the lawsuit could be said to be reasonably related to services you've provided or failed to provide. Now, we're going on to say, make sure to check with an attorney licensed to practice law in your state. But as Phil will tell you, your insurance agent provider can also be very helpful for you here. So
I'll add to that too, is they can pull you into something that you weren't even contracted to do, leak, and someone slipped on some oil in a parking lot, and the sweeping contractor was not contracted to remove oil. Like, it's a hazardous material. There's a little bit of pollution. Those are a little bit trickier cleans. So the insurance company ended up just settling the claim because it cost more to defend it. And they just said, well, here's some money, leave us alone, even though we weren't at fault. And now next thing you know, that sweeping contractor had a $10,000 claim on their insurance for something that had nothing to do with them. So that there's the word that was in that article that you showed was hold harmless and waiver of subrogation. You start to see these terms waive. They want to subrogate. They want to waive the subrogation, and they want you to hold them harmless. Those are kind of red flag terms that let you know that your customer doesn't want to be on the hook for anything, and they're putting it all on your lap. So I'm going to show you a contract. This is a pretty standard contract that most general contractors will use, and a lot of property managers will use the language from this contract because it's so it makes them so safe, so they like it. So this is the an AIA, this American Institute of Architects. This is their document. You can see it's got a lot of copyrights to it, and they have this wonderful section in here called indemnification. And again, this language, just if you're doing work for a general contractor where you might be cleaning up a construction site, there's a good chance you're using this contract or a version of it. And if you're doing work for a property manager or directly for a property owner, there's a good chance that their lawyer or somebody borrowed language from this contract, because it's so in their favor. This is a super unilateral contract. So this language right here of indemnification. So again, any contract you get, you can do that lookup for indemnification. A real easy way, if you don't want to read through the 100 pages they're sending you, I just go, and most programs have this now. You just hit Control F on your keyboard and you just type the word you're looking for, and it will end up, it'll search the whole document for you. So just look up that word indemnification, indemnify, anything that has this kind of language in here. And you can see right here, to the fullest extent permitted by law, you, the subcontractor, agree to be responsible for and shall defend, indemnify, hold harmless the contractor, the project owner, any entity the contractor is required to indemnify in the prime contract, its agents, its representative, its employees, its volunteers, officers, managers, affiliates, everyone. Like you gotta,
company dog, and
yeah.
maybe they didn't forget it. It's probably further down in the.
It is. You know, for, from, and against the cost, the claims, the actions, the cause of action, the damages, the liabilities, the losses, fines, penalties, expenses, including and not, but not limited to actual attorneys and experts' fees and costs. I mean, and that's just the first paragraph here. Like this thing just keeps going on.
So what's happening here, what Phil's talking about is that you are going to come in and do a few construction sweeps, as the example that he used, and you're signing a contract that puts you ahead of the general contractor and anybody else if there's any kind of a claim that they can loosely say that you might have been responsible for or part of, or if it was on the ground. And let's face it, gravity brings a lot of stuff to the ground. So, you just can't afford to sign those kinds of contracts. And what you must do in those situations is to cross out the language that you will not agree to sign and initial it, make sure they initial it, and then make sure you keep that double initialed contract page, because we have, I know of at least one instance where the contractor went to court and on a situation like this, and the third-party vendor supplied a contract that he had signed, but it didn't include the pages where they had both X'd out the indemnification clause, and they had both initialed it. And fortunately, he had his copy where that had been done. Otherwise, they just put the regular boilerplate page in the middle, and then had the signature page at the back, and he would have been on the hook. So make sure to save those copies as well. And there's other language too that Phil's going to talk about here next. That is the type of insurance that's required. And keep in mind that if you have an insurance agent that knows what they're doing in this business, that they can look at these clauses for you before you sign your contract and tell you where the real risks are going to lie. So as you saw, he just typed the word insurance requirements into his into this document, like you can into your contract. They're usually a PDF file, and then look at what your insurance requirements are. So go ahead, Phil.
Yeah, what I would recommend is, before you sign any contract, is send it over to your insurance agent and say, hey, can we satisfy these requirements with the insurance I have? Because what typically happens is the sweeping contractor, they get the job, they sign the contract, they do the work, and then you go to get paid, and then there's someone on the other end that says, sorry, can't pay you because you're not satisfying your insurance requirements. And they won't budge, they won't pay you. It's their way out of not paying you, even though you've already done the work. So the insurance agent, and we're used to seeing these documents, send it over to us, and we'll find some sort of insurance requirement within the document. And really, this is where they start to spell out. And what I did here on purpose is I brought one of the most pain in the butt contracts and one of the most difficult insurance requirements that I've seen in my 20 years of this. So, like, if you can satisfy like a requirement like this, then you can feel pretty confident that, at least from the insurance requirement standpoint, if you get a job, you can satisfy them. So I just want to kind of spotlight some of the things that you need to kind of look for. So first, they need this insurance. They need a certificate of insurance. And it not only do you need it for the time that you have the insurance, but you need to have it for a minimum of 1 year following the completion of your work, or longer if it's required by the main contract. So sometimes you might think that you might be shutting down your business. You're only you had to buy insurance for this particular job, and then once you're done with the job, you don't need the insurance anymore. This right here per contract is saying you have to have it not only during the term of the contract, but also for a minimum of 1 year following the completion of the contract.
So let me break in here to say, as an example of that, and correct me if I'm wrong on this, Phil, but somebody for a short-term project might require a really large insurance liability, like a 5 million, 10 million, something like that. And so you think, well, this is a 3-month project. I'll buy that high-end insurance for 3 months and pay the bill on that. And then I can drop that and drop back down to my normal 1 million or 3 million or 5. And according to your contract you signed, you can't. You have to keep that for a year.
And they'll use that to not, and if you cancel that insurance, you're required to send them something saying, hey, we no longer have that insurance anymore. And you better hope they don't owe you any money, because they're not going to pay you once you tell them you're not satisfying that contract that you have with them. And then there is a level of a breach of a contract that they could sue you if you didn't fulfill this, and it's just more of a headache that they're bringing you into. So some of the
go ahead.
The next one that you'll kind of see is this is a pretty common one. All insurance companies have to have a best rating of a this is pretty standard, about an A, and that's a 7, an A7 or better, an A-7 or better. So that they might stick one other little clause in here. It says, like, all insurance companies have to have this best rating of A7 or better, and they must be an admitted insurance company. So unfortunately, there's not a lot for general liability. There isn't a lot of admitted insurance carriers that will write sweeping contractors. So you just got to confirm that the insurance policy that you have is in fact is rated A7 or better. And if they stick that clause in on an admitted paper, be aware of it. Your insurance agent will tell you if you can satisfy it. And if you can't, prior to signing the contract, like Ranger said, take a red pen and say, hey, I can't do this. This is what I have, take it or leave it. And I'll mention, don't be afraid to do that, take it or leave. Like that's not these are just boilerplate contracts. So you can say, I can't meet these requirements. Like, in order to do that, I'm gonna have to charge you 3 times the price. And the good thing is, if they say, no, we want this, well, your competitor is going to have to sign the same exact contract. and they might end up just doing it. And when they go to get paid, because they didn't check these requirements, they're not going to get paid. And now, now that competitor just did a bunch of work, and they're just not going to ever get paid. And I've fought with prime contractors, property managers, hundreds of times, on specifically on these types of matters, to say, hey, you're paying our contractor. We satisfied this agreement. And there's a flip side to this too. Sometimes they don't ask you for all this stuff. They just have a real simple contract, and then they say, hey, you didn't give us this insurance with all of these special, bells and whistles. Well, you can go to the contract that you signed, and if it doesn't spell out the bells and whistles and all the insurance requirements in that contract, they can't play that game anymore. They have to pay you because you fulfilled the terms of the contract. So I'll keep going down this one because this is a pretty onerous requirement. So in addition to all this, A10, A7 insurance, you have to give a notice of 45-day. So first you have to keep the insurance for more than a year. You have to have an A7 or better insurance. You have to notify them 45-day notice in case of cancellation or non-renewal. So if you get a document or your agent sends you something saying, hey, this insurance company doesn't want to renew you this year, you're required to give a 45-day notice to this contract holder. And then the one exception they give you is, let's say because they don't pay you, you can't pay your insurance, and then it goes into cancellation for non-payment. They give you a 10-day notice. You have to give them a 10-day notice if it's being canceled for non-payment of premium. This is pretty standard. You have to give them a certificate with all the endorsements before the job starts.
And that's something that the insurance organization provides. Is that correct?
Yeah, your insurance agent, when you give them the contract, when you sign everything, you say, hey, send over my certificate. That's the document that they would send. Mm-hmm. What I suggest too is don't have the insurance agent send it to you and then you send it to your contractor. You bring in the person who's requesting the insurance. You bring your insurance agent into that conversation and say, here's my insurance agent. They'll get you everything they need. And if you need anything more, ask them. That way you don't get in this back and forth, arm wrestle match between your contract holder regarding the insurance requirements. The insurance agent makes some money, make him earn his dollar, make him or her earn his dollar, and make them send this insurance document directly to your client. That way it's like you don't have to babysit that it wasn't done. And now you're putting the responsibility on the insurance agent to satisfy all of these requirements. So then we'll jump into this document a little further. They start telling you what type of insurance that you're going to need, like the limits, the type of policies. This one, they want a general liability. It's going to be on a specific general liability form. They want these limits. And then they tell you, hey, on top of these limits, you have to give me all of this extra stuff. And we've had some issues with this, like no exclusion for explosion, collapse, underground hazards. Like you're not doing anything that could lead to an explosion or a collapse. Like that might be like a foundation contractor or an excavation contractor. They're making you, like if you're doing, sweeping work in Florida and you sweep a Rite Aid or something, a CVS, and then 3 days later there's a sinkhole, like now something that had nothing to do with you, you've signed a contract and your insurance now has to defend you for a sinkhole. Like that's just ridiculous. So things like subsidence, and then like there can't be exclusions. Let's say there's multiple people onto that onto your site. Let's say they have a landscaper, and then they have they have a landscaper who maintains the bushes. They have an electrician who fixes the lights, and then you're doing the sweeping portion of the parking lot. Well, this document says if that landscaper does something that produces a loss, like you can't exclude that. You can't have this like cross liability or damage to work performed by subcontractors. Like you can't have an insurance policy that says that type of language. So this is a very restrictive contract, very much so in favor of the contractor and property owner. And no matter what happens on that project, you're responsible to indemnify them. And not only are you responsible to indemnify them with this insurance contract, you're responsible to indemnify them for the main contract itself. So if your insurance doesn't step up and defend you, they have a piece of paper that says that they can sue you personally for it. So that's why I strongly suggest before you sign any contract, have your insurance agent agree that you can satisfy these insurance requirements, and then make sure that they're the ones that send that insurance document to your client. And then in the event that for whatever reason you didn't satisfy these insurance requirements, that burden falls on the insurance agent, and they're the ones that are at fault here. And at least, you have someone that you can say, hey, I asked you if my insurance covered this. You told me it did. You're my trusted insurance agent that I pay a lot of money for. Now I'm going to sue you. And just so you know, us insurance agents, we're required to have insurance that protects us in case we make mistakes like this too. So that type of insurance, if you care, it's called errors and omissions. And in the case that we make an error or we omit certain action on behalf of our clients, then it's our fault and we have to protect you. So we have to have insurance that picks up those mistakes. So this right here applies to just the general liability. Then they're going to go tell you some extra words for your auto policy. And then they're going to stick these two, like this is where you got to be careful. If they start asking for any auto, there's very few insurance companies that will write any auto for a sweeping contractor. They're usually going to do scheduled autos, hired autos, or non-owned autos. So you got to make sure that you meet their business auto requirement. This is just a ridiculous contract. So usually they'll accept, like I said, a scheduled autos, hired autos, and non-owned autos. And if you can't meet this requirement, you can say, no, I can only provide. Your insurance agent will tell you what you can provide, and then you would want to make an amendment to this agreement. And then you can start to see $1 million limit. If applicable, broadened pollution for covered autos shall apply. They start to ask for a lot of this extra stuff. Then they're going to ask for workers' comp. In the state of Washington, that's a state that requires stopgap insurance. So they'll want workers' comp and stopgap insurance. And then they're going to give certain limits. And then they're going to tell you if you need to have an umbrella or excess liability. They'll give you the limits that are required for that. And like Ranger was saying, you might have one client that asks for a $5 million umbrella or excess policy based off the wording of this, and none of your other clients request that. But based off the terms of this contract, you have to buy that policy for 2 years. Even if it's just a one-day job, you're required to keep this high level of insurance. And a $5 million umbrella is not cheap. Usually just kind of a rule of thumb, an umbrella is right around like $1,500 per $1 million of limit. So to meet this requirement, they're spending over $5,000. And then let's see, the next, they might start asking for pollution liability. I'm seeing more and more of that in the sweeping contractor world. You do have this exposure. But a lot of your clients aren't forcing you to get it, but they're getting more savvy to it, and they can start asking for this. So just be on the lookout that most of your insurance, if you don't have a policy that's specifically called a pollution policy, your general liability policy excludes pollution. So you're going to have to buy a separate policy. And like I said, before you sign any of these contracts, make sure your insurance agent reviews it and signs it off on it. And then they're going to give you the language of who you have to send that document off to. So that the two key parts to look for on any contract you sign are the insurance requirements and the indemnification. Those are the two buzzwords. If you take anything from this, look to those, understand what you're getting into, and make sure that you're making enough money on the job to accept the risk or pay for the insurance that is forcing you to pay for the insurance that these customers are forcing you to buy.
That's great, Phil. Really good clarification and examples. One other thing I'd like to talk about is non-competes, and non-competes are something that is also being put into more and more of these third-party vendor contracts, and so be sure to read that part too. And if you're signing to not compete with them, understand what that says. And I'll give you one example that a contractor called and said he wanted to just, and you saw this go out in one of our WSA bulletins a while back, but he was told by his attorney that under the contract he had signed, he was required to go to his third-party vendor for any new client he was thinking about getting within a 70-mile radius of his workspace, and let the third-party vendor, all they had to do was say, oh yeah, we've contacted them at some point in the past and we're hoping to get that business, and then they couldn't have them as a client. So, and also know what happens when you have a situation where you've taken on the job, and let's say for a U.S. Maintenance or a Ferrandino or somebody, and now they lose we'll say Home Depot, they lose that contract with the Home Depot, and Home Depot comes to you, or the new third-party vendor comes to you and said, we'd like you to continue. Are you able, under the language of that contract, able to go ahead and work for the new third-party vendor? Or are you constrained because they lost the contract with the chain, that now you can't continue with the work because of the contract you signed?
Yep. And they can't sue you for that. Even if it's like a frivolous suit, it still takes your time and your energy.
Oh yeah, money takes a lot of that too. So is there anything else we should talk about before we wrap up this particular segment, Phil?
I think we got it. And I would just add that if your insurance agent doesn't want to review those contracts for you, we'll give you a courtesy review, and with no obligation, and we'll tell you, pretty quickly, we'll show you where the pitfalls are, and you can kind of tell your agent, like, hey, can I do this? And you can tell them the work that they need to do, and if they don't take care of you, we know someone who will, right, Ranger?
That's for sure. And keep in mind that when you work with Phil's organization, they are a large-scale broker. Although they can handle your insurance as an agent, they also work with agents all over the country, and they can help educate them about these kinds of things, and make sure they're doing a good job for you. So there is that. All right. Well, thanks, Phil, and
you're welcome.
We'll look forward to whatever the next segment is.
For sure. Talk soon, Ranger.